Hi everyone, thanks for joining us today for LegalVision's Trademarks 101 webinar. My name is Rebecca Jones and I'm a registered trademark attorney and practice leader in the trademarks team at LegalVision.
My name is Gracie Chen and I'm a lawyer in LegalVision's IP team, specialising in trademarks. So our team works closely with a range of clients from startups to enterprises and assists with many aspects of IP and trademark protection, including brand protection advice, drafting and filing trademark applications in Australia and internationally, responding to trademark objections and enforcing trademark rights in Australia.
Today we're going to take you through some trademark fundamentals. We'll discuss the life cycle of a trademark, some common pitfalls, and we'll also discuss some practical steps that you can take to protect and enforce your trademark rights. We should have time for some questions at the end, so please feel free to send these through as we go.
All right, so we'll jump right in and we'll start with looking at what actually is a trademark. So a trademark is any sign that you use to distinguish your goods and services from those of other people. It can be a word, business name, logo, slogan, color, sound, and even a smell. The most common trademarks that a business will initially protect are the business name and logo. As your business grows, however, you might find that there are other aspects of your branding that form a large part of your business and identity and should also be protected. So an example of this is McDonald's. So they have the name McDonald's registered as a trademark, the golden arches symbol, and the slogan, "I'm loving it." These are all separate trademarks that McDonald's uses to represent their company and brand.
Yeah, McDonald's is a great example to demonstrate the different trademarks that a single company can own and have a reputation in. So another example of this is Nike. So this company owns separate trademarks for its business name, Nike, its tick or swoosh logo, and the slogan, "Just Do It." As Gracie mentioned, all sorts of signs can be registered as trademarks. Some examples of the more unique or non-traditional trademark registrations are Cadbury's colour trademark for the colour purple in relation to chocolate products, and Nokia's sound trademark for the well-known Nokia ringtone. As Gracie noted, the most common trademarks are a business or product name, a logo, or a slogan. The other more non-traditional trademarks are relatively uncommon, particularly scent or smell trademarks. In fact, there are only 2 of these types of trademarks on the register in Australia, one being for the smell of eucalyptus applied to golf tees, and the other being for the smell of cinnamon applied to furniture products.
So you might have seen the TM or R symbol used next to a trademark. So the TM symbol is used when you want to claim rights in a trademark and can actually be used anytime before registration. So if you're yet to apply to register your trademark or it's pending with IP Australia, you can use the symbol to show the public that you consider the mark as a trademark. Once your trademark is officially registered and you've received a registration certificate from IP Australia, you can use the R symbol. So displaying the R symbol can be important for putting competitors on notice of your registered rights in a trademark.
Yeah, as Gracie mentioned, the R symbol can only be used on trademarks once they have been registered. And some people don't realise that it's actually an offence under the Trademarks Act to use the R symbol on an unregistered trademark. So it's definitely worthwhile to know the difference. Now, a common area of confusion for businesses is the difference between business name registrations and a trademark. Say you're establishing your business, you've incorporated your company, you've registered your business name with Asic, and you've secured the top-level domains for your name. People are often surprised to learn that taking all of these steps doesn't necessarily mean you will be able to use your trademark. The business name registration helps you to comply with Asic's requirements, but it does not give you any separate rights in the name as a trademark. Although your trademark and your business name registration will often match, a business name registration and a trademark registration are 2 entirely different things. It's not compulsory to register your trademark, although it is certainly best practice to obtain trademark registration. And there are a number of important benefits and protection flowing from registration, which Gracie will discuss in a moment. I also just wanted to mention that aside from trademark registrations, there are also unregistered trademark rights that can exist. So trademark rights can begin accruing from the moment you first adopt and use the trademark in relation to your goods or services. So if you If you have commenced use before registering your trademark, you actually might have started accruing rights in the trademark as you have built up your reputation in the name. As mentioned, it's still best practice to register your trademark.
Yeah, that's a really good point. And as for the benefits of trademark registration, a registered trademark maximizes your brand protection and it affords you with a number of rights, both legal and non-legal. First and foremost, having a registered trademark provides you with an exclusive legal right to use that trademark in connection with the goods and services it's registered for. So as Rebecca mentioned, having a business name registration doesn't provide this right. So this means that you would have the power to commence action against anyone who is using the same or a similar trademark to you in connection with similar goods and services. Competitors are less likely to copy or misuse a trademark that's registered. And without trademark registration, it might be more difficult to stop third parties from copying a brand. Trademark registration also creates a financial asset that you can license and sell to third parties. So you should ensure that you have registered rights to a trademark first before giving someone else permission to use that trademark. So this would be relevant if you franchise your business, for example, to ensure that you have maximum control over how your franchisees will use your trademarks and branding. On a similar note, you shouldn't be selling a trademark to someone else without having trademark registration in place. This is particularly relevant should you ever want to sell your business, and it's something that a purchaser will want to know before buying the business. Trademark registration is also important for attracting investment for your business. In fact, most investors will want to know if you have trademark protection for your brand because it increases your brand's credibility and reduces the risks of disputes with competitors. So this means that investors can invest in your business with a greater sense of security. And finally, registering your trademark will significantly increase your business's professional image and reputation. Being able to promote your trademark alongside the R symbol shows to customers that you take your business seriously and intend to be around for a while.
Okay, so let's go through a brief rundown of the typical trademark application life cycle. So at the very beginning, when you're considering the trademark that you want to adopt for your business, it's important to make sure that this trademark is available for your use and registration. It's much better to find out in the early stages if another business already has existing rights in this trademark, rather than having to rebrand down the track. Getting it right from the beginning can save a lot of time and expense later, so make sure you get your preliminary searches carried out in the early stages of trademark selection. Now, once you've selected your trademark, it's time to apply to register it. In Australia, trademark rights are administered by a government department known as IP Australia. This is who we file applications to register trademarks with. When preparing a trademark application, we include details of the trademark to be protected, whether that's a word, logo, slogan, or otherwise. Details of the trademark owner. Now, this is usually a company, but can also be an individual or in some cases another entity such as an association. Now, we also need to list the goods and services to be covered by your registration. Goods and services are classified into 45 different classes. 1 to 34 are goods classes, and 35 to 45 cover different categories of services. Some of the most common classes of protection are Class 9 for software, Class 25 for clothing and footwear, and Class 36 for financial services. Within each class that we include in the application, we prepare a list of the goods and services that you provide or intend to provide under the trademark. Getting this right is important because it forms the eventual scope of your protection.
So once you've prepared and filed a formal application with IP Australia, it will be assigned to an examiner who will then review the application to ensure it meets the requirements for registration. If your trademark application doesn't meet the requirements for registration, you'll receive what's called an adverse examination report from IP Australia. The report will outline the issues with your application, and you'll be given 15 months to address and respond to these issues. We'll come back to discussing common problems with trademark applications in a moment. If your trademark application meets all the requirements or you're able to overcome any issues within the relevant time frame, It will then be advertised for a 2-month period in which third parties can oppose the registration of your trademark if they have grounds to do so. Only a small percentage of trademarks are opposed, but if it does happen, we suggest seeking advice from a trademark professional to understand your options and likely prospects of successfully defending an opposition. Once your application passes the 2-month opposition period, your trademark will then be registered and you'll receive a certificate of registration from IP Australia. Your trademark is protected for an initial period of 10 years Australia-wide and can be renewed every 10 years after that.
Yeah, so in Australia, the entire application process from filing through to registration usually takes around 7 or 8 months if it all goes smoothly. But as Gracie mentioned, if any obstacles arise during examination, we'll have 15 months to resolve these. So let's discuss some common obstacles that might arise during examination of a trademark application and the way that these can be addressed or avoided. I would say one of the more common grounds of objection is descriptiveness of a trademark. Examiners will assess every trademark application to see whether the trademark applied for is unique enough to function as a badge of origin for your goods or services. If your trademark is descriptive of your goods or services, it's unlikely to be registrable as a trademark because no single trader should own a monopoly in a descriptive or a commonly used term. Now, bear in mind that a trademark might be descriptive in respect of some goods or services, but not others. For example, Apple is registrable in respect of electronic devices in Class 9, but it wouldn't be registrable in respect of fresh fruit in Class 31. Now, if we encounter an objection from the Trademarks Office because the examiner thinks your trademark is descriptive, there are a few options for attempting to overcome this type of objection. The first one is filing legal submissions. If we disagree with the assessment of the examiner, we can put forward arguments about why we think the trademark should be entitled to registration. In submissions, we refer the examiner to relevant case law to support our arguments. Another option is to prepare and file evidence of use. The purpose of this is to demonstrate to the examiner that because of your use and promotion of the trademark, it has acquired distinctiveness. That is, that consumers have come to recognize it as a badge of origin for your business. The amount of use required depends on the level of inherent distinctiveness in the trademark. So the more descriptive your trademark is, the more substantial your evidence of use would need to be. And a final option to avoid a registrability objection is to file for a distinctive logo version of the trademark. Often the additional visual elements contained within a logo can render the trademark distinctive overall and therefore entitled to registration.
So the other common ground on which IP Australia might reject a trademark application is if your trademark is identical or similar to an existing trademark and covers the same or similar goods and services. So the examiner will carry out their own search of the database and compare any identical or near identical trademarks to yours side by side, taking into account factors such as the appearance, sound, the idea of the trademarks, type of customers who might purchase the goods and services, among other factors. So say, for example, you wanted to register a trademark for Aqua Smiles for dentistry services in Class 44, and there is an existing trademark for Aqua Dental covering the same services in the same class. So in this situation, IP Australia will likely raise an objection to your application. There are usually a number of options available for overcoming a conflicting trademark objection, which I will briefly run through. However, choosing the right option and approach to deal with the conflicting trademark can be challenging. So it's recommended that you have a trademark professional help in this situation. So as Rebecca mentioned, you can provide written submissions in an attempt to overcome a descriptiveness objection. The same can be done for a conflicting trademark objection if you disagree with the examiner's assessment. Alternatively, you might be able to amend your goods and services to overcome a conflicting trademark, especially if you have broad claims that overlap with a conflicting trademark that has more specific claims. Any amendments to the goods and services will usually limit the scope of your trademark protection. So we recommend having a trademark professional assist with this. In certain circumstances, you might be able to overcome a conflicting trademark by supplying evidence. that your trademark existed before the conflicting trademark was applied for, or it was adopted honestly and used concurrently alongside the conflicting trademark with no instances of public confusion. Another option would be to approach the owner of the conflicting trademark to see if they would be willing to provide consent to your use and registration of your trademark. So this might be appropriate when you believe there is no commercial conflict between the trademarks. So for example, if the trademarks are used in different industries and have different target consumers. There are, however, risks when seeking consent, including putting the owner on notice of your application and intended activities under the mark. So this strategy should be treated with caution. Finally, you can apply to remove a conflicting trademark if you have reason to believe that it hasn't been used within the last 3 years. You could also potentially use this as leverage to encourage consent from the owner if you go down the path of seeking consent. A trademark professional can help you investigate and assess whether there is in fact any use of the trademark. And you should be relatively confident that the trademark hasn't been used before applying to remove it. And this is because an application for non-use can be quite costly if it's contested.
Right, so that was just a very brief overview of the trademark application process. Now let's look at some common trademark pitfalls and how to avoid them. Now, I would say that one of the most important things to bear in mind is that trademarks are generally not just set and forget. Once you have your trademark registration in place, it's really important to actively monitor and enforce it to avoid having your rights eroded. We will discuss this in a bit more detail soon, but some pitfalls to be aware of are losing your trademark due to non-use, having your rights eroded by allowing third parties to make unchallenged use of your trademark, or a dilution of your brand by third parties using and registering similar trademarks, resulting in the space around your trademark becoming crowded. Another common issue that we see is trademark applicants not getting the scope of protection right in the beginning. So I mentioned earlier the goods and services and the 45 different classes. It's so important to make sure that you get this right at the filing stage. Your specification of goods and services cannot be expanded after filing, so you need to get this right to make sure your eventual trademark registration gives you adequate protection for your intended activities. Also bear in mind that if you expand your goods and services or if you pivot into a different area after your trademark registration is in place, if your new offering is not covered within the scope of your existing registration, you should file an additional application to protect yourself in respect of your new goods and services. The same goes for if you undergo a rebrand or update your logo, make sure your trademark portfolio stays up to date. If you're unsure about whether your current activities are protected by your existing trademark registrations, a trademark professional can assist you by carrying out a gap analysis to identify any gaps in your protection for you.
So as we highlighted earlier, a trademark can be removed from the register if it's not being used. So to reduce the risk of losing your trademark, make sure that you're using it consistently across your business. So this might include using the trademark in advertising, on product packaging, and external documents. On a similar note, it's also important to use the trademark exactly as it's shown on the register, because this is what your trademark is protected for. So this would be required and really important if you ever need to defend the validity of your trademark or enforce your trademark against third parties. As your business evolves and grows, you might need to update your brand's visual representation, such as a logo, to keep it relevant to your business and market. In fact, most famous brands like Microsoft, Kodak, and Adidas have changed their branding and logos over time, and that's okay. As Rebecca noted, if you undergo a rebrand or update your trademark, then you should apply to protect this trademark. Typically, you can't amend a trademark once it's registered, except for minor amendments that don't affect the material features of the trademark, which is assessed on a case-by-case basis by IP Australia. In most cases, though, you will need to file a new trademark application.
Yeah, and so Gracie mentioned non-use of a trademark, which can compromise your rights in the trademark. But another thing to bear in mind is that trademark rights can also be lost when a trademark becomes generic. What this means is that a product becomes so popular that consumers use the trademark to describe this product, whether manufactured by the manufactured by the trademark owner or by other traders. So it's no longer functioning as a badge of origin for a single trader's products. Some ways to avoid this include monitoring use of your trademark by others and requesting or educating them on the correct use. Using it correctly yourself is important as well. Your trademark shouldn't be used as a noun and should ideally be used together with a descriptor where possible, so that the trademark isn't seen as the descriptor itself. So say, for example, your trademark was escalator. You would say escalator moving staircases. This is just one of many examples of terms that were once trademarks but have now been lost to genericism. Other examples include aspirin, linoleum, and cellophane, which were once brand names but are now considered generic names in a number of countries.
All right, before we move to Q&A, we wanted to provide some tips on how to avoid trademark disputes and what to do in a situation if you think someone has infringed on your trademark rights. So we discussed earlier the difference between the TM and R symbol. While it's not a requirement to use a TM or R symbol in Australia, we strongly suggest displaying these symbols next to your trademark to maximize your brand protection. The symbols are used to put competitors and consumers on notice that you have a trademark and can communicate to potential infringers to tread with caution. It's particularly important to display the R symbol once your trademark is registered, as this can serve as a way to put competitors on notice of your registered rights and deter third parties from potentially infringing on your trademark.
Yeah, and aside from other people potentially infringing your rights, you should also bear in mind that you don't want to land yourself in hot water by infringing on any third party's rights. As mentioned, this can be avoided by carrying out preliminary searches before adopting any new trademark or before expanding into different categories to make sure that there are no existing rights out there that might prevent your proposed use and registration of your mark.
So on that note, the Trademarks Act in Australia defines when a trademark is infringed. In a nutshell, a person will have infringed another's trademark rights if they use a trademark which is either identical or confusingly similar to a registered trademark. The person must also use that trademark in relation to similar goods and services that the trademark is registered for. So to use Apple as an example again, if a technology company were to use an image of an apple as a trademark, they might be infringing the trademark rights of the existing technology company, Apple. However, a company which sells apples and other fruits can feature an apple in their trademark because this is in a completely different area of interest and unlikely to be confused with the technology company. There are, however, a number of circumstances where a trademark might not be infringed, and we'll touch on some defenses to trademark infringement in a moment.
So as I mentioned earlier, after your trademark has been registered, it's important to monitor and enforce it where necessary. Keep an eye on competitors, keep an eye on trademark office filings in your classes of interest, and keep an eye on the marketplace so that you can act swiftly if a third party makes unauthorized use of your trademark. A useful tip for quick identification of infringement can be setting up a trademark monitoring program. This involves regular searches of internet listings, industry-specific databases, or marketplace platforms for any third-party use of your trademark. It's important to act quickly to deter any infringers. As mentioned earlier, trademark rights can start accruing from use of a trademark, so you don't want to give third parties the chance to start accruing any substantial rights in your trademark. The first step is usually to send a cease and desist letter to the infringing party. This puts them on notice of your rights, details the offending conduct that you have an issue with, and provides them with a deadline to cease this conduct. In some cases, particularly where it's an innocent infringement, a cease and desist letter can be all it takes to resolve the matter.
Yes, as Rebecca mentioned, when it comes to enforcing your trademark, it's important to get legal advice to understand your rights before taking action. Not every case is black and white, and the infringer might have certain defenses that they could rely on. On the flip side, if you've received a legal letter demanding that you take action, you must understand your rights before responding to it. Defenses apply both ways, and a trademark professional can help you assess whether there are any that you could potentially claim.
Yeah, so some common defenses to trademark infringement include descriptive use. For example, if the term is being used to describe an aspect of the party's business or goods or services rather than being used as a trademark. Another defense is where the second party has adopted the trademark honestly and has been using it concurrently for a period of time. Now, this comes back to what I said earlier about taking swift action. For example, if you were to ignore infringing use for a number of years, but then later decided to try and get the other party to stop using the mark, they may be able to rely on the honest concurrent use defense to infringement. And another important defense to bear in mind is the prior use defense. This is a situation where it's particularly important to do your research. You don't want to send a strongly worded cease and desist letter alleging that another party has copied your trademark, only to receive a response pointing out that they in fact started using the trademark prior to you. As a first step in attempting to resolve an issue like this, we'd recommend getting advice from a trademark professional. We can carry out the background research required, advise you on the strength of your rights versus those of the other party, and ensure that you're taking the best approach to resolving the matter. So hopefully, yeah, we've got some time now for some questions. So let's take a look here. We've got a question here. Are trademarks industry specific, i.e. can I register a trademark someone else already has if I operate in a different industry? Now, Gracie touched on this a little bit earlier, and the answer is yes, but there are some grey areas where perhaps one class of goods might be considered similar or related to another class of goods. So it really depends on the consumers, the trade channels, whether there's any actual risk of consumer confusion occurring. But coexistence certainly, it is an option in some cases.
All right, another question we have is, does the trademark registration protect you globally or just in Australia? Which is a great question. So trademarks are on a country by country basis. So registering a trademark in Australia would only provide you with protection in Australia. So if you did want to expand to other countries, you would need to apply to register your trademark there. There are different ways to apply internationally. So the first main way to protect a trademark internationally is to file a direct application there. The other option is there's a international filing system which allows you to apply to multiple countries based on your corresponding Australian application. And it's usually a popular way to protect a trademark in a number of countries because it reduces the filing costs and streamlines the application process. But you would still need to nominate the countries, the individual countries that you want protection in.
Yeah, so I've got a question here as well, which relates to international trademarks. If I register in Australia but want to sell in the US online, can I do that without getting a US trademark too? Now, any country that you're operating in, it's recommended that you get trademark protection in place. You wouldn't want to start selling on your website from Australia to US consumers and inadvertently infringe on an existing trademark right in the US. And similarly, if you start building up a reputation from your sales to US consumers, you want to be able to enforce your trademark against other people in the US that might adopt a similar or the same trademark. So definitely worthwhile protecting your trademark in all countries where you are trading or where you're selling to consumers.
All right, when applying for a trademark, you are actually applying for a registered trademark with our symbol. So like we touched on earlier, you can only use the registered R symbol once you have a registered trademark and you've got a registration certificate from IP Australia. In the meantime, you can use the TM symbol at any stage before registration, and that shows to competitors and consumers that you're claiming that mark as a trademark.
Yes, so I've got one here as well. Just want to make sure, so the R symbol next to the logo, does it have to be placed there? I see some brands that are trademarked but don't have the R symbol next to their logo. So in Australia, no, it's not compulsory to use the R symbol, So that's used to benefit the trademark owner to put third parties on notice of those rights, but it's not mandatory, but certainly recommended.
All right, another question. Interested in finding out more about how trademark registration helps a business and what to do if another business has a similar name to you. Yeah, so as we outlined, there are a number of benefits that flow from trademark registration, both legal and non-legal. One of the main benefits is that as a registered trademark owner, you have the exclusive use of that trademark. And having a, like Rebecca mentioned, having a registered business name doesn't provide that legal right. So if someone were to come along and start using a similar trademark to you in a similar space, then you would have the power to commence action against them and request that they stop doing that.
Yeah, so I've got another one here. Do you trademark the logo and company name together or separately? Now, this is a great question. So we find that the best protection would normally be, and most businesses adopt this approach, is filing for a word mark for their business name, and then also filing a separate logo application to protect their overall visual logo and branding. So the word mark protection gives you really broad protection in that term. It protects you in any font or color combination that you might decide to use that term. And then the logo registration gives you an additional layer of protection in the overall kind of look and feel of your branding and those additional visual elements that you use with your branding. So definitely worthwhile considering registering both versions.
All right, so can you please elaborate on the difference between registering a business name with Asic and registering a trademark? So yeah, this is a quite important difference, and it's a common question we get from a lot of our clients. And in fact, yeah, a lot of people don't know that there is a difference between registering a business name and trademark. So to clarify, the business name registration helps you comply with ASIC's requirements. So if you're trading under a business name that's different to your company name, you need to register that business name with ASIC in order to legally trade under that name. But this doesn't give you any separate rights in the name or the power to stop other people from using a similar business name. And that's where trademark protection comes in. So you will need to register that business name with IP Australia as a trademark in order to have exclusive use of that name and the power to stop other people from copying that name.
Yeah, so a good way to think about that is if you have just the trademark registered but not the business name, the trademark isn't going to protect you from an ASIC perspective if you're not complying with ASIC's requirements. And if it were the other way around, say you have the business name registered but not the trademark, the business name registration isn't going to protect you from infringing a third party's existing trademark. So they're all part of an IP portfolio or steps you take to establish yourself, but they're both separate and both important. What have we got here? Do you have to trademark variations of your logo? Now, if there are variations of your logo that are really similar, say you use it in different colors, or perhaps there's a little tagline that's kind of descriptive of your services, so you use brand name and then your little tagline for different branches of your business, those types of changes, because they're not material and they don't affect the substantial identity of the trademark, you can often apply for what's called a series trademark for those variations of your logo. So this means that you could file, 1, 2, 3, 5 versions of your logo in the same application to protect all those different variations. But if you are using, substantially different logos and different aspects of your business, then it's definitely worthwhile protecting all versions of your logo.
Yeah, and the only thing I'll add to that is if you use the logo in different colors, so the only difference between the logos is, the colors used in it. We normally apply for logos in black or white, as this provides protection for the logo in other color variations.
Yeah, that's a good point there, Gracie.
And on colors, someone has asked, can you register colors and phrases? Absolutely. So as Rebecca mentioned, you can register a color as a trademark. It's one of the more non-traditional trademarks we see, but it's certainly possible. So an example that we gave was Cadbury's color purple is registered as a trademark. In terms of phrases, yes, you can also register phrases and slogans or taglines as trademarks. On that, the same requirements would apply. So you need to make sure that the phrase or the tagline, doesn't describe what the product or service is and isn't, laudatory in any way.
Yeah, and on the color trademarks, I'll also note that they're relatively difficult to obtain. So you can't just, go out and obtain a trademark for, the color of furniture, for example, because you want to hinder your competitors and stop them from producing furniture of that color. So I think a lot of the time it would probably be necessary for the applicant for a color trademark registration to provide significant evidence of their use of the trademark to demonstrate that consumers are recognizing that as a trademark and as a badge of origin for their goods or services. So yeah, I definitely think there are some additional hurdles there to getting a color trademark registered. So what if you have abbreviated business names? Can you register an acronym as a subsection to the business name, or does it require its own registration? That's a great question. Now, typically you would need to register that acronym as a separate trademark. So you'd have the one trademark registration for your business name. And if you have, it's essentially a secondary trademark. If consumers are also referring to your business by this acronym, then that's a separate trademark and you should apply to register that one separately.
All right, so when is the right time to make a trademark application? For example, if you're a startup just establishing your brand, is it important to begin the trademark registration process early or wait until you go to market with your service? That's a really good question. So, and yeah, another common question we get is when's the right time to register a trademark and protect my brand? As a general rule of thumb, the earlier the better, especially given the 7.5 month application timeframe it takes to register a trademark. But it really depends on your priorities of the business and where you're at. If you're a startup just launching your brand and you're looking for investors, for example, it is, like I mentioned, important to at least have have a trademark application in place, because that's what a lot of investors will look for when they're looking at your business and making sure that you have at least started that process before they invest in your business. On the flip side, we have clients who have been trading for a number of years and come to us at that point to register a trademark, and that's fine as well. But overall, I guess it's good to get your foot in early, especially to reduce the risk of someone getting in there before you, and securing that priority date, which is the date on which you file your application, and the date that your application is given preference over later filed applications as well. Did you have
Yeah, that was a great question. No, I think you've covered that very well. So I've got another one here. Can you just keep using the TM symbol without ever applying for the registration? And the answer is yes. It's not compulsory to register your trademark. I mean, we discussed earlier some of the benefits flowing from registration. And I also mentioned that, you start accruing rights in your trademark from when you start using it, so before you even register it. But one of the really, one of the core benefits to registration is that if you wanted to enforce those rights against a third party making unauthorized use of your trademark, it's much more of a burden to try and enforce unregistered trademark rights, because you've got to put on evidence to establish your reputation in the trademark. So there's a big evidentiary burden. Whereas if you are taking action for trademark infringement, you produce your trademark registration certificate issued from IP Australia, and it's much more of a black and white kind of straightforward proceeding.
Is there a limit on the number of slogans, e.g., I'm loving it, that can be registered to a business? So there's no limit. You can register as many trademarks as you want, but you need to make sure that you're using the trademark, because like we mentioned earlier, if you're not using your registered trademark, it could be vulnerable to be removed by a third party. So you need to make sure that the trademarks that you're registering are you're using those trademarks and they are adding value to your brand.
Yeah, absolutely. So there's no limit on how many trademarks a company can register, but there probably is a limit on how many trademarks a company can use and maintain over the years.
That's right.
So yeah, definitely. How can I receive funds from someone using my trademark? What kind of agreement is required? Now that's a great question. So this is trademark licensing. So you would want to put a trademark license agreement in place. It would set out the terms of the agreement and the royalties that would be paid to you, or the license fees paid to you as the trademark owner. So that's a trademark license agreement.
Is it worthwhile using the R symbol for a TM used internationally and not just within Australia? That's a good question. So you would only be allowed to use the registered R symbol within Australia if your trademark is registered here. It's a little bit trickier when it comes to international countries, because if your trademark isn't registered in that country and you're using the R symbol next to the trademark, then that might potentially be in breach of trademarks law there. Rebecca, did you have any other thoughts on that?
No, I think it's probably something that requires a little bit more consideration. So if you were in that situation, I'd suggest reaching out to get some advice, particularly, where are your trademarks located? Where are you shipping to? Where are the goods being manufactured and exported from? So there's probably a few layers of different considerations there before deciding, the best approach in terms of your product packaging if you're shipping to multiple countries.
Yeah, absolutely.
Do you have any other questions there?
Yeah, I've got one more. Can I trademark my name? Yes, you can. So you can trademark your name if it's basically not a common name. So so you wouldn't be able to register John Smith, for example, as a trademark. But you can certainly register your name as a trademark if that's your brand and that's what people identify you as. So a lot of celebrities, I'd say, have their name registered as a trademark. But yeah, it's something that you can definitely also look at. All right, I think that's all the time we have for questions.
Excellent. Okay. Well, as a final point, we should mention that your trademark protection forms only part of a business's overall IP strategy. So your trademark registration is just one tool in an IP protection toolbox. When combined in a full IP protection strategy, for example, including things such as online terms of use, IP clauses in manufacturing or distribution agreements, or IP clauses in employment agreements, or IP licensing arrangements, then you're really putting yourself in the best position to protect your business's IP.
And on that note, we're offering attendees of this webinar a free strategy session to discuss your brand portfolio and business more broadly, and how LegalVision can help to support you. Attendees of this webinar will also receive a free month of access to our LV Connect membership. You'll just need to click yes to the pop-up that you will see after the webinar, and leave your contact information to receive a free strategy session.
Thank you for tuning in today, and we look forward to seeing you in future webinars. If there are any particular topics from today that you would like us to take a deep dive into in future webinars, we'd love to hear your feedback and suggestions. Thank you.
Thanks, everyone. Bye.